You're listening to the Valley Current.
Whenever judges get overwhelmed with paper, it leads, and it's a good segue to the argument that happened yesterday in the U.S. Supreme Court in this Section 230 of the Federal Communications Decency Act. That file is just overwhelmed with paper, mostly from amicus briefs from both sides coming in. And I'll put it up on the screen because I really doubt that any single judge or even set of clerks read all these briefs. I mean, I don't know if they use some summarization tool, like maybe a AI-based summarization tool, because it's just too much paper. I mean, if you look at, I'm at SCOTUS blog, which I think is the go-to resource if you're doing research on pending cases. And if you look at the SCOTUS blog, this was a Ninth Circuit case. One issue really, does Section 230C1, so it's a subset of the Act, immunize interactive computer services, really social media, when they make targeted recommendations of information provided by another information content provider, really by user-generated data, or only limits liability when they engage in traditional editorial functions, such as deciding whether to display or withdraw. So it's sort of like saying, Section 230 survives. All that happens is there's a listing or a delisting. But if the AI algorithm, which is what this really is, makes an actual recommendation, is that like a form of activity that might lead to some sort of harm? Because the story in this case is that the AI of Google was causing some, effectively some forwarding of hate speech or some sort of speech that caused the death to someone in the Gonzales family. So it's pretty serious allegations, and imagine that now there's going to be wrongful death cases that are brought against social media companies. I mean, it's kind of an interesting question, right? Because I think in law school, we wouldn't ordinarily say that somebody who's kind of republishing something and maybe even directing it is causing whatever occurs in the superseding event that generates the firing of the bullet or the shooting of the rocket or whatever it is that occurs. We'd call that a superseding cause, breaking the chain of but-for causation. Exactly. Where if you're looking at, and you will get this in law school, Lynn, if you're looking at this concept of causation, it has two elements. It has but-for the activity would the consequence have occurred, and the but-for test is pretty broad because lots of things can be, past that test. And then there's more of a legal test called proximate causation, where it's, well, is it really something that people would see as a foreseeable cause? It's something that you could say justifiably should trace some liability, maybe even what's sometimes called comparative causation or comparative fault or comparative negligence type liability. And the interesting part of this case, which I think the arguments would be worth listening to, but they're pretty lengthy, is that the justices, at least one of them, but I think all of them, were sort of admitting in a very humble way, we're not the experts on the internet and on internet policy. And indirectly, I think they're saying, and the lawyers aren't either. In other words, all this stuff should really be cast at Congress and ask Congress to modify the act if the act is going to be modified. The act has sweeping language, but look at what happened from April of 2022 to October 2022. There's just very little filing. There's a filing of a petition. There's a filing of of an opposition by Google. There's a reply by Gonzales, 3 briefs, maybe they add up to 100 pages. And then the petition is granted, like literally 5 or 6 days after what they say was the distribution for the September 28th conference. So they have like a month to read that 100 pages. You know, they probably get summaries and whatnot from them. And then there's basically a bunch of time to deal with getting other stuff filed, including the various appendices. And then there's, you know, all these amicus briefs that start in November and then go in December and then continue December. Look at all these filings by December 7th, you know, which was the filing deadline date. And then there's the thing is set for argument, and then there's, you know, dates in which the distribution of certain briefs occur. It's kind of interesting because it's saying, you know, this Professor Eric Goldman's brief got distributed, certain briefs were not accepted, and then they list different other briefs, amicus briefs that are being distributed. And I guess they probably distributed all of them, but, you know, January 19th, I mean, how much time between January 19th? I mean, if you really count the number of briefs here, you know, the argument happened a month later. Could they really absorb what's thousands of pages of amicus briefs in that 1 month period? I just, you know, find it phenomenal that they even make a suggestion that they do, but they do, or they say they do. And that's a lot of paperwork. Yeah, that's a lot of information, and you can put them in buckets, you know, neutral briefs, briefs in favor of the industry, briefs in favor of really plaintiffs' lawyers, really plaintiffs' contingent fee lawyers and their litigation funders are what's most interested in this. And I don't really know what the truth is about how this stuff gets summarized, but at some point, I think someone's going to spill the beans and say, look, the reality is not every word of every brief, or certainly not every word of every amicus brief, gets read. And maybe not even the summaries get read, right? I mean, that's the question. Like that would be an interesting question if there was an ethical rule that required, you know, radical transparency. What would that look like? You know, what would that transparency look like? And what would be required in that transparency? So, you know, you get this case, it's pretty significant. There was oral argument yesterday. The New York Times report, which summarized it in today's newspaper, front page report, made it pretty clear that it looks as though they're just going to say Section 230C1 stands as it's written, and there is no, no change to it. I forget what the actual ruling was on the Ninth Circuit. I think summary judgment had been granted in the underlying case, throwing out the plaintiff's claim, and I think that was affirmed by the Ninth Circuit. I'm pretty sure.
The Ninth Circuit basically said that Section 230 would protect an internet company's automatically generated recommendations as long as they're treated equally. So they created kind of like a neutrality test. And actually, one of the justices, Supreme Court justices, criticized that. As I think it was Gorsuch. He said, you know, it's not anywhere in the statute. The interesting thing is that one of the justices made a comment that, well, because tomorrow they're going to hear the other case, which a similar case where somebody was, it's brought by a family of an individual who was killed in a terrorist attack, but the Section 230 issue isn't before the Supreme Court. And one of the justices commented, well, if we rule that you just can't sue internet companies under the Anti-Terrorism Act, then do we even need to get to the Section 230 issue? So it's possible that they could rule on this other case and then not even have to rule on the Section 230 issue.
So they probably should have heard them together, but maybe they just didn't have the time in the day, right? Is that set for oral argument today or this week?
I believe it's tomorrow.
Yeah, I mean, if you're a Supreme Court watcher, and there are people who literally are Supreme Court watchers, I mean, they literally camp out at the court, not only for newspapers, but for hedge funds, for investment firms, for all sorts of like people from SCOTUS blog, because they have, they have an interest in seeing the sentiment of the Supreme Court. Like, to my way of thinking, and I said this on LinkedIn, this is one of the first oral arguments where there seemed to be a bit of humility. You don't usually get the justices or any of them saying, look, we basically are not the sharpest knives in the drawer when it comes to understanding the internet or the law of the internet, or maybe even more broadly, any of this technology law. Like, if you really want to take it to its limits, the actual humble statement would be, we're just a group of 9 lawyers. That's what we were. We weren't scientists. We weren't engineers. Some of us were all of us were judges, I think. Is that right? I think all the existing Supreme Court justices were previously federal judges of one type or another. And we dealt with all kinds of cases, but we didn't have any expertise in Section 230 or in the internet or social media. And we don't have any expertise now. I mean, look, most people think expertise takes 10,000 hours of actual experience. That is, if you go to law school and you pass the bar, maybe you could argue you've got a few thousand hours of expertise. But the truth is, to practice law, most people would say 10 years, and that's probably more than 10,000 hours of experience, is like a minimum requirement. Maybe if you're really doing a lot of cases and getting a lot of real time in court, maybe it's 5 years. I don't think it's ever less than that. And that's why becoming a partner at a law firm is typically a 10-year hike. In some cases, it can be less. Years ago, it used to be less. But in general, they don't have 10 years of expertise dealing with these topics. They have expertise understanding the policy issue, but weighing the weight that should be given to one set of policies versus another. I mean, look, ChatGPT, which I sent around before we started this discussion, it gives a fairly good summary of the pros and cons of the arguments on Section 230. I mean, did that in 30 seconds of typing. I mean, not even 30 seconds by me. I usually dictate these things, and they take just a few seconds if the voice translation works out. And then it comes back with a fairly substantial response. In most cases, I've been pretty impressed. In this case, I was pretty impressed. And it's a fair summary. And in general, what it doesn't do is it doesn't say, the set of pros outweighs the set of cons. It just leaves it to the reader to decide. And in many ways, that's kind of what SCOTUS is signaling right now, which is we don't know how to weigh these pros and cons. The pros and cons need to be weighed by Congress. We're not in a position to weigh them. That's what Congress does. Congress weighs pros and cons and has debates and talks through the issues and votes. And there's some form of democracy in all that. But in general, I don't think that people think somehow the Supreme Court in certain areas, probably people would say that's true in most technology matters. They probably would say that's true in most IP matters. Trying to weigh these pros and cons is actually pretty hard for most people. It's interesting. This quote is captured the newspaper, right? I mean, can you imagine? This gives a pretty detailed description of the case about this death that happened via an ISIS attack back in 2015 in Paris. And the case is in the U.S. because the defendant is Google, and Google's in the U.S. You would think this should be handled by a court in Paris, right? But it was filed under the Anti-Terrorism Act on banning, aiding, and abetting terrorism by, among other things, recommending ISIS videos. That's a federal statute, right? So, you got one federal statute saying one thing, you got another federal statute saying another thing. And, I don't know who, I don't know who's funding Gonzales. I got to believe there's a litigation funder involved somewhere in this. And that ties to some of our discussion about litigation funders and their roles. But in general, it just seems to me that, listening or reading what different justices are saying, these are not like 9 greatest experts on the internet, is what Kagan said. And I don't think anyone went and said, no, we are. Kavanaugh seemed to support what Kagan said. And I don't think any of the others said, oh, yes, we are, right? I mean, the truth is, the generalization is they're not experts on most things most of the time. And yet they get to decide, and they have to decide, because there isn't any special master that they can refer things to. Although I'll tell you, in certain cases, like disputes over water rights between 2 different states, they realize they're not experts at all, and they refer those cases to a special master who is an expert, who does effectively, I'm not going to call it an arbitration, but effectively he or she will do a report and recommendation on what should happen from a very technical point of view. So there actually are instances where the court does delegate some arguable decision-making, or at least foundation for decision-making, to an expert. And they're not going to do that in this case, because it's not like, well, someone's got to get out and do measurements and take photographs and do a bunch of stuff involving water rights. I think there is a case like that that's currently before the court, or has been before the court, dealing with the drying up of the Colorado River and what that means between 2 different states that are fighting over water rights. But you don't see that. You rarely see that. And I've never seen it in the context of a statutory business dispute or civil litigation dispute involving an individual and a company, or 2 different companies, or 2 different individuals. It's only where the court has the original jurisdiction over a dispute between 2 different states, where it's completely different gravity of the situation. And oddly, there they do delegate. I mean, we know federal judges in the district court level can appoint neutral experts. I don't know what a neutral expert would do with this, because it's not really a technology issue. The AI is getting better and better, and the AI is automating a lot of things. And part of the automation is causing certain things to be published or to be promoted, and certain things to kind of get lost, right? Or to be.
It's really a policy issue, in my opinion, and that, like some of the justices said, that should be resolved by Congress if they're going to act. I mean, Congress, they did act when they enacted the Section 230, and that was a policy decision that they were going to have, they were going to protect internet companies. And now it's kind of like, okay, well, is that the best policy? But that's not really for the court, to decide. I agree with the justices that say that this should be an issue left to Congress to resolve. I had a question. Do you think that it would be a litigation funder, lender? I mean, or just taking this case for the publicity and potential, damages for wrongful death? I could see an attorney who's well off saying, hey, yeah, I'll take this. Or do you think there probably is some funder behind it?
I think there's likely a funder behind it. I mean, there's always the possibility that there's somebody more substantial, like a billionaire, who's just throwing money at things that they think need to be changed. There are certain billionaires who think that social media has become too powerful and that something needs to be done to sort of rein them in. And if that's so, it's not hard for them to cut a check for a few $1 million to support the entire litigation at the district court level, at the Ninth Circuit level, and in the Supreme Court. Now, whether they'll also fund what you could argue was the failure of a checklist in Congress, because you could argue, hey, you've passed this other statute that says that anyone that's aiding and abetting, shouldn't we explain and decide as part of the statute whether Section 230 trumps the statute we just passed? Or, we got to jive these things together. I mean, we can't just let it be silent. That's going to result in a lot of disputes and a lot of litigation, right? And you could say that's sort of a checklist item, which is, as you're drafting legislation, what's the effect of the legislation on other existing law? Section 230 has been law for a while.
As I recall, as far as just, in the state of California, so we would, we come up with bill ideas. When I worked for certain members, we were drafting much more of the legislation than others. But then you send it to the legislative council, and they draft it up. They'll make changes, but as far as I remember, they give you like a conflict, or they raise issues that this could conflict with this statute or that statute. As far as I recall, we would receive, or at least we would receive a letter if there was a constitutional issue. I know that, and I think, if I recall correctly, that they would raise issues with it conflicting with other statutes. I don't know if that's how the similar to legislative council in California works in Congress, but as I recall, there is. I mean, because that gets down to like canons of statutory constructions, right? The Congress doesn't pass a law that would conflict with another law, and then the court might try to resolve that in a way that allows both of them to survive, right? And so I think it kind of ties into some of that. I mean, I don't know if that will come into play with 230, but I could see how those canons could play a part in how the court might resolve the issue.
I mean, to my way of thinking, if Congress was really thorough, they would have a checklist along the lines of what you're describing, but it would not just be a human being. It would probably be something that is baked into some advancing AI program that does permutations around different aspects. Like, it's not hard to imagine aiding and abetting making its way to YouTube videos and Google's promotion of certain videos. Yeah. It's foreseeable. So the question is, maybe it was foreseen by legislative council, whatever that parallel is in Congress, and they just said, we're not touching this. We're just going to let it stay the way it is. Or they actually said, no, the reason we're not touching it, you have to go through the legislative history. I imagine it would have been covered in a brief, and then one of the justices would have said, wait a minute, there's legislative history that Section 230 came up in the context of looking at this question of whether there should be a carve out. And they said, no carve out. So they dealt with it. And as far as we're concerned, that's the end of the story. There's a lot more to be said about it. And you might end up saying, I suppose, that that's kind of what they are probably hoping to search for, is some legislative history that suggests that Congress touched the issue. Now, if Congress didn't touch the issue, then you get into what are the ordinary rules of interpretation, where there's one statute that says one thing, another statute that says another thing, but there's the more recent statute that says another, right? I mean, there's usually a rule around that says the more recent statute might well trump the old statute, right? I mean, if it has a definition of aiding and abetting that says including but not limited to using digital media to carry out the aiding and abetting, then you get closer to, well, maybe they did affirmatively decide this. Now, I would think if Google probably put a huge amount of money into this case. I want to say that Lisa Blatt was the lawyer who argued from Williams and Connolly yesterday. And, Wilson Sonsini has done a lot of Google's work historically in Silicon Valley. And, I would think, let's just quickly look at their brief in the table of contents. I would think they would have some citation to legislative history if that were true. If they effectively, there was something.
Yeah.
They're citing there was a bill to repeal Section 230 in 2021, and that didn't pass. So that's relevant to some degree.
Sure.
There's Abandoning Online Censorship Act. I don't know if that did or didn't pass. Allow states and victims to fight online sex trafficking. I don't know if that did or didn't pass. Anti-Terrorism Act. That's the act that's sort of in play here against the Communications Decency Act. And, I haven't gone through the briefs in any detail to be able to say one way or the other to what degree. But if it was there and it was addressed,
it would be addressed. I would think it'd be addressed in the committee analyses. So we get back, like, again, just using California example, you get something back from Ledge Council, says statutes like the bill proposal is unconstitutional or would conflict. A member would often be like, okay, thank you very much. Have a nice day. I'm going to introduce the bill anyways as written. And then it's really up to the committees to bring up these issues. And so it would be very similar, like in that table of contents, in all the committee analyses, they list out other legislation, past legislation that touches the issue that whether it passed or not, as I recall. So a lot of that, again, in California, I've looked at judicial, like congressional committee analyses, and they do the same as far as I recall. But the issue, I think, is just, was it foreseeable back in 96, right, and passing the Section 230 that it could be, I guess you're saying with the aiding and the abetting with the Anti-Terrorism Act. I'm trying to think, like, what'd you say about how you're talking about how those two acts would work together? Yeah, the aiding and abetting of the Anti-Terrorism Act. So I'm not sure how that plays in, because in 96, was it foreseeable that this act could potentially allow an individual to aid and abet terrorism? They would have to have foreseen that at the time, right? Isn't that kind of what you're talking about?
Yeah, to me, the real question is, when they passed that act, the latest act, no aiding and abetting of terrorism, did Congress say anything about Section 230 at all?
Yeah, I see what you're saying.
Did they make a judgment? And you could argue that's really what Justice Kagan's point is. That's a judgment call that Congress should make about the intended scope of the aiding and abetting. Now, you still might get some interesting questions. I don't know if they're appropriately subject to summary judgment, but interesting questions about what does it mean to engage in aiding and abetting? Because if someone is publishing this ISIS video, is that aiding and abetting the fact that they're not preventing that uploading? Usually if there's an uploading and it's objectionable, someone can ask for a takedown. Whether it's taken down or not becomes kind of a First Amendment issue to some degree. But, if it's really inciting murder or rape or maliciously wrongful conduct. I mean, that's all sorts of.
I'm not sure what the standard. Yeah, I can't recall what like the criminal aiding and abetting standard is. But I mean, don't you need some sort of affirmative act? And so would that algorithm, could that be an affirmative act?
Yeah, they're saying, the plaintiff is saying in a very broad way, which was the other criticism, that he's not drawing any lines that are helpful. He's just saying anything and everything that involves a republishing recommendation, if that's what it is, that is a form of activity that can constitute aiding and abetting. Effectively, that what should have happened is they should have been able to put some algorithm to work saying this is hate speech, or this is inducing criminal conduct. We've got to shut this down. We got to review it. We got to stop it before it's published. And that should have happened, and it didn't happen. And, here's page 3. Maybe this is coming a bit late. Petitioner claims, to the extent based on, quote, targeted recommendations under Ninth Circuit precedent for lack of proximate causation and insufficient substantial assistance. I mean, basically, the defense arguments are, this is not the proximate cause. The proximate cause is whoever committed the murder, or whoever committed the crime. Now, we know, just to sort of use a helpful analogy, that years ago, landlords used to say the same thing about murders and rapes that happened because their properties were dark. And they could have put lights and cameras and all sorts of security mechanisms around their apartment buildings. And the law eventually held that if landlords don't do that, they might be somewhat at fault for what the criminal does. So we know that the law has gone in the direction of broadly defining when someone may be a factor in the causation.
And that kind of gets into, I mean, as like in the landlord context, it's risks of which they are aware, right?
Well, they would say Google is aware of all these crazy events, right?
Yeah. I mean, there's certainly an argument that YouTube, Google was aware that their algorithms were generating this content and directing it, and they should have known, or that they should have known that it could have led to what happened. There's certainly that argument.
Yeah, I mean, to me, it's along the lines of Facebook knows that certain people live stream crazy activity, and they probably have a bunch of filters, or they try to figure out just how crazy that activity is. And the filters only work so well.
Yeah.
People do all kinds of things to get around the filters. And the result is problematic because stuff slips through, and then events happen, whether you want to call it a mass shooting, a school shooting, various things happen. And then it's like, are they a substantial contributing cause to what happened? And that's kind of the argument that this plaintiff is making. And these social media folks are like, look, if we're now going to have to deal with lawsuits left, right, and sideways, that's a big cost for us to undertake. B, the federal courts are going to be filled with new cases, as the state courts as well, because Section 230 applies across both. Look, Section 230 has been applied in California's SLAPP defenses to allow social media companies to get cases dismissed based on this federal immunity across all sorts of what is otherwise claimed to be tortious behavior. So in many ways, it's like social media is growing rapidly, continues to grow rapidly because there aren't filters, and people put a lot of stuff up all the time, and some of it is distasteful, and some of it's probably illegal. And the truth is, the information platform or the social media platform, they want to keep the content coming because they get ad revenue, right?
Exactly. Yeah.
I mean, the people that click on this stuff are also clicking on ads. And so there is a sort of profit-making aspect, but it does lead to weird outcomes, including, of course, as we know, what happened in the 2016 election when Russia bombarded social media with, tons of stuff that was either false or misleading or deceptive, and there are reports about it. And they're probably going to bombard social media again in the 2024 election. And it's, how much of that is going to get filtered and how much of that is going to deceive people that are going to believe whatever it is that's sent. I mean, it's very hard to talk about causation. I mean, to me, like the statement on page 6, petitioners do not allege that Google had any role in encouraging or committing the Paris attack. They don't allege that the attackers were recruited by YouTube or that they used YouTube to plan the attack. The link is only that, quote, an active user of social media, including YouTube, who once appeared in an ISIS propaganda video. I mean, it sounds pretty thin factually, and maybe that would otherwise, if the case were allowed to go forward as some sort of exception to Section 230, it would be the case just doesn't rise to aiding and abetting under the Anti-Terrorism Act. But Section 230 is meant as a broader affirmative defense so that the social media company doesn't have to spend the time and money defending the case. Effectively, the case should be over at the earliest stages.
Well, I think what some of the justices are saying is that they rather decide whether I think that exact question, whether this kind of activity arises to aiding and abetting, decide that issue. And if they decide no, again, then they don't have to get to what could be potentially a more disruptive decision in the internet industry if they say, okay, it arises to aiding and abetting, and then also, yes, 230 does not protect this. So that will be interesting. It'll be interesting to see what happens tomorrow at tomorrow's argument.
Right, and they could choose to dismiss the Gonzales versus Google petition as, quote, improvidently granted. If they decide the second case in a certain way, and effectively say, what the Ninth Circuit decided is okay, and we're going to leave for what might be called a more appropriate vehicle for deciding Section 230. I mean, look, they could have taken Section 230, the Section 230 case, with the view that they wanted to signal to Congress exactly what they signaled in the oral argument, which is this is a matter for legislation. I mean, Congress is reading this stuff. There are congressional pages that I'm sure are sitting in the Supreme Court, at least, in the gallery, listening to what they're saying and then reporting back to their respective senators and Congress people, hey, we got to actually put together a bill that addresses how Section 230 works or doesn't work with the ATA, the Anti-Terrorism Act, because, those 9 people up there don't want to decide it. And, you could argue that maybe that's the reason they took this, just to engage in what might be called the grandstanding, if that's what this is. Because ultimately, look at all the litigation expense and time that's spent, vetting this issue. And they really never really wanted to decide it to begin with. If you want to take kind of a jaundiced view, they just took it to send a signal, a very direct public signal, that there's certain areas that they really feel are appropriately dealt with by Congress and not by the courts, and not by the federal courts at all. And whether that leads to a broader legislative view of Section 230 or a more nuanced one, because you made a comment about this, Taylor. You said it looks like the Biden administration is taking a more nuanced view of how Section 230 should work, right?
Yeah, well, it was interesting. I sent out an email today. So I read, it was just a CNN article that I came across a couple of days ago. And originally, and then I read it again today. I clicked on it today just to review it, and it had been updated. And I swear they changed their description of the Biden administration's amicus curiae brief, because I originally thought that the brief was saying that was in favor of the protections and that of 230, and that the algorithms are protected free speech. What I'm seeing now is actually Biden's been critical of I looked into a little bit more. He's been very critical of Section 230, and so what they said that Section 230 does not protect Google and YouTube from lawsuits for failing. Does protect the internet platforms from failing to remove third-party content, including content it has recommended. But the government's brief argued these protections do not extend to Google's algorithms because they represent the company's own speech, not that of others. So the Communications Act is protecting those internet service providers, website contents from, publications by third parties. Biden is saying 230 doesn't extend to the algorithms because that is the company's own speech. So then I guess you come in with what are the limits on free speech, right? Wouldn't that be the next step, so that you can't be propagating, insightful, propaganda, like language or videos, or is that, I'm just not sure exactly what they mean there. I think they're saying that these algorithms are.
Your argument this morning in case 21-1333, Gonzales versus Google. Mr. Schnapper?
Let's just take a minute.
Justice, and may it please the court.
Let's take a minute.
Section 230C1 distinguishes between claims that seek to hold an internet company liable for content created by someone else and claims based on the company's own conduct. That distinction is drawn in each of the three sections of the statute. First, Section 230C1 is limited to claims that would treat the defendant as a publisher of third-party content. The statute uses publish in the common law sense. The Fourth Circuit decision in Henderson correctly interprets the statute in that manner and concludes that it involves two elements. The claim must be based on the action of the defendant in disseminating third-party content, and the harm must arise from the content itself. Second, Section 230C1 is limited to publication of information provided by another content provider, which is often referred to as third-party content. The statutory defense doesn't apply insofar as a claim is based on words written by the defendant or other content created by the defendant. In some circumstances, the manner in which third-party content is organized or presented could convey other information from the defendant itself, as the government notes. Third, Section 230C1 only applies insofar as a defendant was acting as an internet computer service. Most entities that are internet computer services do other things as well. This court technically is an interactive computer service because of its website. It does other things as it is doing today. Conduct that falls outside that line of activity is outside the scope of the statute. A number of the briefs in this case urge the court to adopt a general rule that things that might be referred to as a recommendation are inherently protected by the statute. A decision which would require the courts to then fashion some judicial definition of recommendation. We think the court should decline that invitation and should instead focus on interpreting the specific language of the statute. I welcome the court's questions.
Now, what's wrong with that? I mean, the way it works now in the Supreme Court and in most federal circuits, and maybe now even to some degree at the district court level, is you get like a couple of minutes, sometimes up to 3 minutes, to do the overview. To me, his overview was not impactful because it was turgidly burdened by interpretation of the statute as though the court didn't know that interpretation. They want to hear the policy argument. They want to hear the pros and cons that ChatGPT summarized. You could almost say the ChatGPT summary would have been a better opening by him than what he did. I'm not trying to be overly argumentative here, but until he got to the very end, like the last 30 seconds where he said, it seems as though what's the problem here is Section 230 is being too broadly applied, and let me explain why. And then bang, 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 bang would have been his policy arguments. Instead, he did what I would call the lecturing about the statutory law. Everyone knows. I mean, it's like wasting the whole punch. So let's stream forward. Let's see if I can do it. We stream forward to maybe, I think he was supposed to get 45 minutes, but I think he was given more. So let's stream forward if we can, 60 minutes, and see if we can get to Lisa Platt. Well, maybe she'd be at 45. Maybe they gave amicus some aspect. So let's see if this does it.
It will inevitably happen, and has happened, that companies have devised practices which are maybe highly laudable, but they don't fit within the four walls of the statute. That will continue to happen no matter what you do. And the answer is when someone devises some new practice that may be highly desirable but doesn't fit within the four walls of the statute, the industry has to go back to Congress and say, we need you to broaden the statute because you wrote this to protect chat rooms in 1996, and we want to do something that doesn't fit within the statute. And using thumbnails would be a perfect example of that.
Thank you.
Justice Gorsuch? No, and if I might explain why. Briefly. I'll do my best. The language that you refer to in section F4 doesn't apply here.
No, we'll get to that in a minute. Let's just take that as given, okay? That I think that what, say, Google does in picking, choosing, analyzing, or even digesting content just makes it an active software provider. Let's take that as given. And so that would normally be protected activity. But F3 carves out and do something beyond it. As I take your argument, you think that the Ninth Circuit's neutral tools rule is wrong because in a post-algorithm world, artificial intelligence can generate some forms of content, even according to neutral rules. So the artificial intelligence generates poetry, it generates polemics today. That would be content that goes beyond picking, choosing, analyzing, or digesting content, and that is not protected.
This is arguably ChatGPT that he's referring to, and Bard and other AI enhanced compilation engines, and that's part of what you could say is indirectly implicated and might be part of the signaling the Supreme Court is saying this area is big. And Congress has to deal with it, and it can't be that it's the Supreme Court that's going to draw the right lines, because Congress can bring in experts, they can ask professors, computer science professors, mathematics professors, semantic experts, people that explain how English works and what's understood. I mean, there's so many different, there's psychological aspects, there's so many different aspects here. But I wanted to get to what Lisa Blatt's opening is, because, you know, I guess they gave him more time. I don't know where the right number is for where we go here. So let me just scan ahead.
Decision and force. And of the 8 justices.
What about the implications then? Go to that. The implications for the economy, that you have a lot of amicus briefs that we have to take seriously that say this is going to cause a lot of economic dislocation in the country.
This is Kavanaugh.
I'd say a couple of things in response to that. The first one is, on a close reading of the amicus briefs, it's clear that they're urging the court to hold that.
I mean, to me, it's sort of like, you know,
protected as long as I'm quoting somebody else. And I don't think anybody.
I guess I don't understand. I mean, let's see. I guess I don't understand logically why your argument wouldn't mean that I was creating new content if I retweeted or if I liked.
I want to get to Lisa Blatt, and unfortunately, they don't do an easy way to figure it out, right? I mean, that's the unfortunate thing of this audio. The audio comes up there pretty fast. So you got to give them credit for that. I mean, literally, it was just done yesterday. And it also doesn't fast forward very well.
And then recommendations.
There should be like a little button that says, you know, fast forward 30 seconds.
Yeah.
So let's see if I can get to 60 minutes. Else we'll just have to do this some other time when I have better preparation.
And honing in on this, are you actually creating content or just presenting third-party content?
Well, I've been answering. That's where the questions have taken us. But our view would be that you're not being treated as a publisher of the video just because you published the thumbnail.
Okay, thank you.
You're not being harmed by the thumbnail.
Thank you.
Justice Jackson?
So I guess I'm thoroughly confused, but let me try to.
Who's the most favorable to the family?
What the argument is. And I think that the confusion that I'm feeling is arising from the possibility that we're talking about two different concepts and conflating them in a way.
So I'm just going to look at the transcript, and to me, the transcript suggests there's a total of 178 pages, and Lisa Blatt starts because she's not the second speaker. The second speaker is actually the Solicitor General as sort of the neutral, expressing the Biden view. That'd be worth listening to separately. This thing goes for two hours and 40 minutes. So I'm going to guess it's at the 2-hour point, perhaps, that Lisa Blatt starts, because that would roughly be 2/3 of the way through, maybe. And let's see if we can get there. Let's see what this is.
Brings up all of the ISIS videos and tees them up, and if you don't do anything, they just keep playing. Why that's actually different than the newspaper publisher who gets the offensive content and decides to put it on page 1 versus page 20. It seemed like Congress in 230 was saying if under the common law, a newspaper publisher would be liable for having put it on page 1 or whatever and given it to people, we don't want that to be the case for these internet service companies. And so I don't know that I understand fully why the fact that that you call it a recommendation or whatever is actually any different.
I guess one difference I would point to is newspaper publishers can make decisions about what will be on the front page and what will be in the back, but it's going to be the same for everybody. And one of the things about...
That's the Solicitor General. So let's go one more try and go a little further forward. And 2-hour mark. Maybe that's too far, but let's see. This is probably too far, but.
And so we shouldn't be faulted because his complaint doesn't allege anything wrongful. No, but in your hypothetical, where someone could say,
that's Lisa Blatt. So
That's her. So back up.
last time, I don't know where the line is here. I'm going to guess it's roughly at, the 2-hour mark.
Did by YouTube or Google. And so although
whatever the liability issue may be, there's some issue tomorrow, we'll talk, there are a lot of others. The presence of an immunity under 230C, it seems to me, is just not directly applicable.
Well, that's incorrect because of the word recommendation. There is no word called recommendation on YouTube's website. It is videos that are posted by third parties. That is solely information provided by another. You could say any posting is a recommendation.
That's Lisa Black. So she started, and we're not getting the actual opening, which is what we want.
I guess one difference I would point to is newspaper publishers can make decisions about what will be on the front page and what will be in the back, but it's going to be the same for everybody. And one of the things about why we call them targeted recommendations with YouTube is they are being sent differently to different users. And the situation we're concerned with is, what if a platform is able through its algorithms to identify users who are likely to be especially receptive to ISIS's message? And what if it systematically attempts to radicalize them by sending more and more extreme ISIS videos? Is that the sort of behavior that implicates either the text or the purposes of Section 230C1? And we would say that it doesn't.
Thank you.
Thank you, counsel.
Thank you.
Here she goes.
Slides coming up now. This is all in person, by the way. They're back in court now.
They're back in person, yeah.
Not by phone.
Section 230C1's 26 words created today's internet. C1 forbids treating websites as, quote, the publisher or speaker of any information provided by another. Publication means communicating information. So when websites communicate third-party information and the plaintiff's harm flows from that information, C1 bars the claim. The other side agrees Section 230 bars any claim that YouTube aided and abetted ISIS by broadcasting ISIS videos. So they instead focus on YouTube's organization of videos based on what's known about viewers, what they call targeted recommendations. They say that feature can be separated out because it implicitly conveys what viewers should watch or that they might like the content. But accepting that theory would let plaintiffs always plead around C1. All publishing requires organization and inherently conveys that same implicit message. Plaintiffs should not be able to circumvent C1 by pointing to features inherent in all publishing. C1 reflects Congress's choice to shield websites for publishing other people's speech, even if they intentionally publish other people's harmful speech. Congress made that choice to stop lawsuits from stifling the internet in its infancy. The result has been revolutionary. Innovators opened up new frontiers for the world to share infinite information. And websites necessarily pick, choose, and organize what third-party information users see first. Helping users find the proverbial needle in the haystack is an existential necessity on the internet. Search engines thus tailor what users see based on what's known about users. So does Amazon, TripAdvisor, Wikipedia, Yelp, Zillow, and countless video, music, news, job finding, social media, and dating websites. Exposing websites to liability for implicitly recommending third-party content defies the text and threatens today's internet. I welcome your questions.
So that's far more impactful. Indeed, I've been thinking there's probably a great idea for a website that would just grab the first 3 minutes of every opening and just do a commentary on what's impactful versus what's not impactful. Yeah. And it's unfortunate they don't do that. They don't make it easy. They don't tie the transcript in a way that's useful. They don't do any, I mean, Supreme Court just publishes the stuff as it is. Yeah. It'd be nice if the transcript flowed in with it and so on. But in many ways, I've been thinking, there's a lot of lessons in advocacy here because these people spend a lot of time and a lot of money, not only in the briefing, but in constructing the argument. Yeah. And that first 90 seconds can set the structure up for what plays out and how that plays out in the course of the questions and answers. Mm-hmm. And that's what it has to do. It has to provide a structure that the advocate can go back to over and over and over again and answering questions. And that's true for all oral arguments, whether you're at the trial court level, the appellate court level, or the Supreme Court level. And so in many ways, there's so much learning that we didn't get in law school that Lin Yan and others will get now if the law school professors are good about tying in oral advocacy in the Supreme Court and some of the cases, because the law is moving pretty quickly and the cases are moving quickly, and we have all of this digital media. It's all there for free. You just go to the Supreme Court website, or you go to the SCOTUS blog website, or just at least a dozen others, where it's hopefully summarized, hopefully organized, hopefully makes life easy. And just for my money, comparing those two advocates. Now, we didn't listen, and maybe we'll do it on Friday if there's time. But generally speaking, listening to all three, in this case it was Solicitor General, to see how they put their nuanced position, which sounded like a middle ground position between what were otherwise the two very extreme positions, one being kind of the industry, the plaintiff's bar, personal injury bar kind of view, the other being the industry view. I mean, those views are out there in lots of other contexts as well. I mean, to me, it's kind of interesting to listen to the advocacy and just compare that first 3 minutes of what's presented. And then if you really did the deep dive, it would be how well did the structure enable answering the questions that come down later down the road. And to me, that's what well thought out opening statements in oral argument are all about. They kind of think through, well, what are the likely questions that are going to be asked, and what is a way to bring back a theme? And her theme was Congress already made this decision.
Yeah.
Very much, right? I mean, exactly what we talked about at the very beginning. Congress made this decision. It's final, it's binding. You don't need to revisit it. This case probably shouldn't have been accepted. It's sort of the subtext of it. That's what her original brief was, the original Google brief was. Once they accepted it, Google was pretty surprised, I imagine, and said, well, okay, we have to do the best we can. They had the advantage of the Ninth Circuit ruling, but usually if the Ninth Circuit ruling went a certain way, you would think they would just let it lie and wait to see what the other circuits do, because I don't think there's really a circuit conflict here between the Ninth Circuit and another circuit. I think the circuits are more or less taking the very broad full immunity view under Section 230. I know that certainly the district courts have taken that view because it cleans up their docket. It makes the docket easy to maintain and to get rid of these cases for at least some period of time and wait to see what happens. It's a little bit like a slap. It's a little bit like a slap immunity in California, in California practice, where, hey, if something can be subject to the strategic lawsuit against public participation immunity, then that immunity gets heard, and if it's ruled in favor of the defendant, the case goes away. And that's it. It goes up on appeal. Okay, let the appellate court deal with it for a few years. It gets it off the trial court's docket. Yeah. So a lot of learning there. Sure. And we'll probably come back to it because it really does provide some advantage in thinking about how you organize for an argument and then how you organize to best present at an argument. So I think we should end here. Lin Yan, you should check the tentative rulings. I'm hopeful it will come out by 2 p.m. and then we'll have another call at 2:30 and see what flows from that.
Okay, sounds good.
Right,
okay,
thanks, Jack. Thanks, Lin.
Tune in next time on the Valley Current.